The dash you Davis here. Yeah, you, okay, I'll just check the choice with your iPhone, so I'll understand that you're here. Okay. All rise.
Seated. Morning, everyone. Welcome to the August docket of the Court of Appeals sitting here at the Sedgwick County Courthouse. I'm Tom Malone. To my right is Judge Catherine Gardner. To my left is Judge Rachel Pickering. We are the panel for today's cases. I'll call the cases in the order of the published docket. We only have two this morning. And at that time, we'll get the appearances of the attorneys. Before we get started, I'll just say a few preliminary things. You probably know, but we have read your briefs, so we're familiar with the facts of your case and what the issues are. You might keep that in mind as you make your argument. Each side is given 15 minutes for your argument. The appellant's attorney should let us know in advance if you wish to reserve any of your time for rebuttal. After the hearings this morning, your case will be deemed submitted for decision. And after that, we will take the case under advisement and get a written opinion out to you and your clients just as soon as we possibly can. So with that, I'll call the first case on the docket. It is from here in Sedgwick County, number 129-058, entitled RF versus EF. Counsel wants to come forward. Who do we have here for the appellant?
Good morning, Judge. Jennifer Hill is here for appellant RF or EF. I'm sorry.
And for the appellee?
Ashley Davis of Pennerlow Law.
Ms. Hill, you can come up to the lectern. Do you wish to reserve any of your time for rebuttal?
Yes, good morning, Judge. We would like to reserve 4 minutes for rebuttal.
That is granted. You can begin whenever you're ready.
May it please the court, my name is Jennifer Hill. I am here appearing today on behalf of appellant, who is also the respondent in the underlying matter. Initials are EF. Because of the need for initials under the court's rules, I would request, if it's okay with the court, that I just refer to the parties as mom and dad. Seems to me to make the most sense. It's the easiest to track and follow.
That's fine.
We go that way. Your Honor, we're here today on a domestic case. As you are all aware, these domestic cases get filed, I think, at great frequency at the Court of Appeals level. I think it's really important that the court keep in mind timeline of the facts of this case. The parties were married in 2011. In May of 2022, mom filed here in Sedgwick County for divorce. There was not a trial on the matter until May of 2024. So we had 2 years of litigation leading up to trial. And that is a critical fact in this case because of how the case evolved during those 2 years from the time of filing until the time of trial. The court issued its ruling from trial in July 2024. And in November of 2024, the dad filed his motion to reconsider. The court heard that motion. An order was entered on that denying all requests for relief and reconsideration February of 2025, and then this appeal followed. The reason that timeline matters is because from the date of the filing in May of 2022 until trial 2024, we had changes in how the custody arrangement had been initiated. The parties agreed to allow dad more time. And the reason that matters is because over the course of those 2 years, obviously the parties are getting used to in 2 households. The parties are figuring out how do we make this new arrangement work. And by the time of trial, every witness in this record before you, the parties, the character witnesses, the family members, all testified You know, at the end of the day, these kids are pretty lucky. They've got two good parents. And in fact, the district court's finding was that the children were, quote, thriving. That is the court's word. And that it would make the most sense to maintain the status quo. Meaning, what we're doing here in 2024 is working. Despite that finding, the court then reverses itself essentially within the same order, taking time away from dad. That is absolutely contrary to the facts of this case. The parties understand, and I understand as I stand here today, I've got a high burden. I've got to prove abuse of discretion to change the court's ruling on the issues that I brought for you. I brought for you 2 property issues, 2 financial issues, and 2 custody issues. We have to show abuse of discretion. Well, this case is that case, because if you review the record, you'll see that this isn't a typical domestic case where we have a competing therapist for mom that says kids would benefit from being with mom, and a competing therapist from dad that says, or social worker that says, oh, they do better if they were dad. We don't have that in this record. What we have is unilaterally, dad's a great dad. He's involved, does a good job with the kids, he works from home. Basically, we have this record that says, and even mom herself testifies, it's a great father. Despite that finding, the district court goes back a year and a half to a recommendation, not a decision, a recommendation from a domestic conciliator who in December of 2022, long before we've gotten to the arrangement we're at, that domestic conciliator says, well, due to dad's work schedule, I do think we'll reduce his time a little bit. So the court goes back in time and takes an old opinion from a conciliator who hasn't seen the parties or the kids in a year and a half, who doesn't have the same conclusion that the kids are thriving in 2024. And we have this now decision that doesn't make sense. It's inconsistent with its own findings. That is abuse of discretion. I'm not asking you to sit here today and find that from the transcript, I'm going to decide one witness is more credible than the other. I'm not asking you to do that today. I'm asking you to go with what the evidence already is. This is almost like a summary judgment where we have undisputed issues of fact. As we get to the grandparent visitation issue, which is the second issue in my brief, that is another one where, again, we have an undisputed record. We do not have grandparents who have filed motions and hired attorneys.
And I was going to ask you, is there, what's the basis for grandparent visitation? Is there a statutory basis?
There is a statutory basis, Your Honor. And if we go, this is a funny situation in that there was one statute in effect at the time of trial in 2024, May. July of 2024, Kansas legislature passes a new statute. So this case kind of straddled the 2 statutes.
And that's the word you used in your brief, straddle. Which statute is appropriate?
I
I
believe
assume that the correct, the judge needs to make ruling of the statutory.
it's the second statute, Judge, because by the time we filed motions to reconsider and we're evaluating grandparent visitation and challenging this order from the court of July of 2024, I believe by that point in time, we are working with the new statute. But in this case, it doesn't matter. The award fails under either statute.
Well, the district court didn't attempt to apply either statute, did you?
Correct. There was no discussion of the statute at all. It was, I find there's a relationship, and because there's a relationship, I'm gonna award these 7 uninterrupted days of visitations, 1 for each said grandparent.
Can I ask you to go back to a more fundamental question? Without a motion filed by the grandparents, was a ruling even appropriate?
We argue no, Judge. We say that is in fact a complete misstatement or a misuse of the law. It was a sua sponte, came up with it. The petitioner mom had said, I want grandparents to have visitation. But that was part of her arguments to the court, but there's no motion. The parties themselves who have the ability to file that motion and advocate for that visitation are the grandparents themselves. The grandparents have to assert standing, and under the new statute, they have to show that they have a substantial relationship with these minor children. Obviously, in today's day and age, we know of situations where grandparents have these sort of substantial relationships where the children live with them, where they're responsible for daycare and pickup every day after school. That's not the record in this case. The record in this case is we have 2 maternal grandparents, one living in Arizona with a stepmom, one living in Minnesota with a stepdad. The children have never had unsupervised visitation with grandpa, never. at the time of trial.
What do you say to, I think mom's argument is that the grandparents weren't seeking visitation, so the statutes don't apply.
I respect that. However, that doesn't change the fact that we need to change the court's order. The court's order should nullify, we should nullify that finding by the court. I understand that mom wants to take the kids to go visit the grandparents. We don't object to that. That's not the issue. The issue is that the court didn't have jurisdiction to even award that visitation in the first place. So if the mom chooses to take her time and her vacation to go visit those kids, that's fine. That's not the issue. The issue is, as the order stands today, those kids are ordered to go to Arizona for 7 days, Minnesota for 7 days, or a location of their choice. Obviously, they can decide to go on a cruise or something like that. That's not part of the order. But the issue is that these grandparents don't have standing in this case, but we awarded that visitation anyways. And frankly, in a situation where we're already taking time away from dad from what we had in May of 2024, it's just further evidence of the cumulative error of this order. This is one of those cases where we dispute and argue with a number of the court's findings, right? We probably, if we got down to brass tacks, we'd argue about the dollars awarded from one 401k to another. We understand that the court's not going to lift those kinds of decisions, right? Absent other problems that we don't have in this case. Those are judicial discretion issues.
Has there ever been a ruling of a judge ordering grandparent visitation under the best interest of the child? Without any statutory consideration,
Not that I'm aware of, Judge.
or without any motion by the grandparent?
Not that I'm aware of it, not that I could find. In the cases where we have awards of grandparent visitation, typically there's social workers involved. Maybe there's some concerns about the fitness of the parents. And usually the grandparents are a vested party. I've litigated cases where grandparents actually filed child in need of care actions against their own children to get visitation and custody of those grandkids. That's a legitimate purpose and a legitimate way for the parties to get to that point. But we don't have that in this case.
So what is the remedy with respect to this one issue?
To the grandparent issue, it would be to remand the case back to the district court to remove that portion of the visitation order. And then as it relates obviously to the child custody, we would ask that the court at the very least reinstate where we were at in May of 2024, when the finding was the children were thriving and that the status quo should be maintained. That would be our request as it relates to those things. Obviously, this is an ongoing case. These are young children, these are minor children. The facts are going to change. There's this material change in circumstances arguments that domestic parties make where they come back and say, hey, it's changed again. We think that custody should be changed. We're looking at that moment in time when this decision was made in summer of 2024. And we understand that the ongoing litigation, there may be changes, continuous changes, right? As the parties' finances and as the kids grow, all these things are malleable over the course of the divorce. We understand that. But what we're asking for and the relief we are specifically seeking is that we go back to the 2024 order of court and that we remove these errant findings.
But didn't the mother have legal custody, primary custody since birth?
Of course, yes,
So are you asking for a joint custody
yes.
award?
I mean, we're looking for shared ultimately, right? But what we're first looking for is joint. And then as far as the spousal maintenance goes, I'll address that during my time on reduction.
Thank you, Your Honor. May it please the court. The parties have joint legal custody. They've always had joint legal custody. Ms. Hill is incorrect in that the district court said, hey, the kids are thriving, maintain the status quo. She's picking and choosing what she wants to maintain as the status quo. The status quo was, since the birth, mom was a stay-at-home parent. She was the primary parent for these children. During the pendency of this action, she remained the primary residential parent of these children. Yes, dad's time was expanded, but let's talk about that. He had Tuesdays and Thursdays, and after about 3 months, and there's a disagreement on when that happened, she agreed to let him have overnight, but that was not a shared arrangement. During a domestic case, you don't count the time the kids are in school. And so, to be clear, because dad only had Tuesday overnight until the following morning, Thursday overnight until the following morning, he had 42.14% of the time with the children. That's not a shared arrangement. A shared arrangement is 50%. The domestic conciliator, and also, so during the summer, he actually had even, that would have gone down to 37.28%. Because again, then the kids are not in school, so that time increases. So his time would have, of the overall time, decreased. After the trial court's ruling, now he has, I apologize, now he has 37.28% compared to the 42.14%. That's a difference of about 4.86%. Again, in the summer, it would have been less, and so it went from 32% to now he has 29%.
Did the parties agree that the Tuesday, Thursday was too much back and forth?
Yes, the record is very clear. Both parties testified. They told domestic conciliator Yost, too much back and shuffle. That's clear in the record, and I believe I cited that in my brief. They thought that was too much, and I will tell you, I do domestic all the time. It's a lot of time to be changing from one house to the next. And so dad complained that, hey, I've only got about 4 hours by the time I go get the kids, because dad lives in Cheney. The mom and children live in Goddard, go to school in Goddard. He was like, by the time I get home, have to do dinner, you know, that's not very much time. And so what the recommendation was, okay, we're going to expand it. Also, his weekend parenting time was only Friday at 5 until Sunday at 5 p.m. Friday till Sunday at 5 p.m. Friday. Domestic conciliator Yost said, you know what, we're going to expand his weekend. So he has every other Thursday after school until Monday morning. So there's less back and forth. So basically, and then the Thursday preceding mom's weekend, he gets Thursday after school until the following morning at school, or 8 a.m. if there's no school. So basically, he used to have Tuesdays and Thursdays overnight. Now he has Sunday overnight. So the domestic conciliator took away 2 Tuesdays in a month, or 1 Tuesday in a 2-week period, because now he has a Sunday overnight to make up for that. That's not a lot. More importantly, again, the domestic conciliator said, because his parenting time used to end at 8 a.m. on Friday morning, and then if it was his weekend, he got them again at 5. So there's that 8-hour period where he didn't have the children. Now he has that. So Mr. Freeze actually has more waking hours with the children under the new schedule. And again, the parties never had a shared arrangement. So when the court says, we're going to maintain the status quo and the kids are thriving and doing well, that was under mom having residency of the children. And again, so I believe the court did not abuse its discretion. And also, I want to be clear, neither parent was asking to maintain the current schedule. More importantly, there are about 18 statutory factors the court is to look at in determining residency and parenting time. 9 of those favored mom as the primary residential parent. The others were neutral. There were none that favored giving dad shared residency. And we can have 2 great parents. Because you have 2 great parents doesn't mean that both parents are automatically entitled to 50% of the time with the children. It's what's in the best interest of the children. The court heard 3 days of evidence and determined, yes, mom thought the domestic conciliator's recommendation was in the best interest of the children as well. Because again, she thought the too much back and forth. Both parties agreed on that. Regarding the grandparent, because I think I'm going to run out of time, regarding the grandparent visitation, it is not grandparent visitation. I tried to make that clear during the court. They're trying to do that. They're trying,
Are you saying that the judge's order is not grandparent visitation?
it's not grandparent visitation. The district court provided a mechanism where the children could spend a week, because grandparents live in Arizona and Minnesota, which is a substantial distance, 1 week with them. And maternal grandma had done that over 3 different years. She had done that. She had watched them. Maternal grandfather, not necessarily, but yes, he had a close relationship. The problem is, and the court was very clear, and if you read the record, the evidence was at trial, these 2 parents never seemed to agree on the most basic facts.
But when, I'm sorry, what would you call it if it's not visitation? Colloquially, that just seems the perfect fit as far as the statute goes. And why do you say it's not visitation?
Because it's not visitation, as in the sense the grandparents didn't file a motion asking, hey, we want to be entitled to a week with the children.
Wouldn't that have been appropriate?
If they wanted that, yes. They're not the ones who asked for this. Mom asked for it. And the reason mom asked for it is because these parents can't reach agreements on the most basic facts.
Then why shouldn't it come out of mother's visitation?
Well, it does come out of mother's time. So let's be clear, under the current schedule, so dad has, the grandparents get 7 days. Under the current, and it has to come out of mom's weekend. So it has to come out of mom's weekend. The only day that dad is missing is 1 day, because he gets the Thursday preceding mom's weekend. So he is missing 1 day, and he's not actually missing it because he gets to make it up within 90 days. And he has done that. In 2025, the grandparents each had their 7 days. He made up his 1 day weekend, or his 1 day. Actually, one of them wasn't made up within 90 days. My client let him have it after it was, even though it was after the 90 days. The problem is, and if you recall the testimony, when mom had Memorial Day holiday weekend during trial, she had asked him well in advance if she could take the kids out of state, because under a temporary order, you can't leave the state with the children without agreement of the other parent or order of the court. She asked dad, he would never answer. At trial, I asked him, hey, it's mom's upcoming, because this is May 1st, 2nd and 3rd. It's mom's Memorial Day weekend. She wants to take the kids out of state for her Memorial Day holiday. Can she do that? And he was like, well, I want to see how this is what's gonna happen at this trial before he answered. On redirect with his counsel got him to agree that yes, she could take them out of state. Also during the pendency of this action, when mom wanted to take the kids to Minnesota during her vacation time, dad would only agree if she let him take the son to Kansas City for a monster truck rally, which mom agreed. But again, the only way he would agree to let her, and she can still use her vacation, but the children, again, the court found the children, they have a close relationship, and the evidence was they do have a close relationship with both sets of grandparents. Dad is the one who testified he repaired the relationship with the maternal grandfather and my client, which would have been her dad, and after they got married. And so the evidence was they do have a substantial relationship. But again, I don't believe that this is visitation.
So
Instead of,
what is it? Could the judge have just simply said, let me ask you, normally you have to have the other parties' permission to travel out of state, but if it's for grandparent visitation, you know, something where you could qualify it.
well, you only have to have the permission under a temporary order. You have to get permission. So that's under the temporary orders, you can't leave the state. So again, can do it afterwards, but so if she wanted the kids to be able to spend uninterrupted time with the grandparents, only both of the parties get 7 days of vacation. She'd have to be giving up her vacation to let them have time with their grandparents as well.
So here's the problem I have. I have a statute that went into effect of July of 24 about third-party visitation. How does this case not follow under that statute?
Because in my opinion, the court provided a mechanism. So instead of wasting the domestic court's time, so, hey, mom says, hey, I want the kids to be able to go spend time with their grandparents for a week. Can we trade some days and you? I will tell you, these parties can't agree on, again, the most basic of facts. That didn't happen unless dad gets more than what he wants, or he would be like, you have to do X, Y, and Z. And so instead of filing a motion every year to allow this to happen, which clutters the court just made a mechanism that says, you know what, dad is not missing any parenting time. He gets to make it up. So we are not depriving him of his constitutional right. But instead of the parties having to come back to the court every year for when, hey, mom wants to send the kids to grandma or grandpa's house for a week, they provided a mechanism to allow that. So we're not every year saying, hey, the kids want to go to Minnesota over the summer for this week because, hey, there's this going on and that going on. And dad says, well, I'm not going to do it unless I get 2 weeks.
So the justification for not following the statute is convenience?
No, it's not following the statute. It's not grandparent visitation. It's a mechanism in which the court is allowing mom to give her parenting time to the grandparent without, okay, we have to file a motion with the court because dad's going to miss his 1 day. Because it's 7 days, dad's going to miss his 1 day because there is such a substantial distance between Arizona and Minnesota. These kids haven't flown. They typically, again, are driven. That's a whole day trip.
My concern is under this mechanism, it's shortcutting a statute that the legislature put in to ensure always child safety, child welfare, best interest of the child. They get to go around that by creating a mechanism.
Well,
And I'm worried about that
Mhm.
because third-party interaction with children is very important. We want to make sure it's maintained, and yet to hear that there's a mechanism to ignore what the legislature has ensured that there's factors that are considered by the court. See, by not following the statute, we have no factual findings of whether the court actually considered these factors that the legislature said we want courts to consider.
and that's if the third party files a motion to ask for that visitation. Grandma and grandpa didn't do this in this case. This was mom's concern that dad's not going to allow her and switch time with her to let the kids go spend time with the grandparents. That's why the request was in the parenting plan, and the court, again, dad testified. So also I want to remind you of dad's testimony. The court specifically asked dad, okay, what is your plan? Because in that non-party situation, you're supposed to defer to a parent's preference or their proposal if it's reasonable. Again, mom's proposal is a week. Dad didn't have a proposal. The court specifically asked him, hey, what is your proposal to allow the kids to maintain this relationship with both their maternal grandmother and grandfather? And he was like, well, I'm going to work with her. I don't really have a plan. I don't have a definitive plan. And through the testimony, again, you will see it doesn't really work. These parties can't really reach, sometimes they can reach agreements when somebody gives a lot in, but again, it's typically not that. And so to prevent that and prevent us going to the court every year saying, hey, the kids want to go to see grandma and grandpa or grandma, maternal grandma in Minnesota for this week because, hey, this is going on and this is what they're going to do. And dad is going to say, well, I'm not going to do that unless in exchange I get a week of my time, which again, it has to come out of mom's time. And so that's what the grandparent did. Regarding the, again, because I'm regarding the spousal maintenance, again, the court did not abuse its discretion. The court made a finding that, yes, considering all the factors, dad had the need, or mom had the need, and dad had the ability to pay. Mom did not have, she was awarded $3,000 in spousal maintenance under the temporary order at a modification hearing because dad said, ooh, I'm only going to make $171,000. Shocker, lo and behold, oh, in 2023, he made $330,000. He was making $16,905 a month, including his bonus. My client is making $14,000 a year. He had the ability to pay, she had the need. They talk about the DRAs and how they changed. again, when mom first filed for DRA at the initial of this case, she hadn't been paying the bills. She didn't know what the bills were. She didn't know a month from now when she filed an amended DRA. At time of trial, she testified she took an average of 12 months of all the bills except for food, which was based on last month's food. She had a need. More importantly, the parties had split a savings account of about $130,000. My client had to use that to supplement her income. She wasn't making it. And so the court, again, awarded $4,500 in spousal maintenance. He had the ability to pay. They made reference that, oh, coincidentally, shortly after the court's ruling, he lost his job.
You
And-
have 1 minute.
He lost his job and, hey, he can't afford to do it. The court said, I'm not going to modify it now because he got a severance package that it was over $11,000 a month, averaged over 12 months. The court has since modified it based on his severance package has ended. And he has now new employment, which coincidentally is with his former company that was bought out by the company now. And so again, the court did not abuse its discretion in anything. We think you should affirm all of the decisions. And again, because of the problem with dad agreeing to let the children go see their grandparents, he's not missing any time. The court has provided the judge, instead of us harassing her every year on this, says, okay, dad gets to make up his time. He can choose to do it whenever he wants. He has 90 days. And again, my client let it go past the 90 days. It's in the best interest of the children. The court found that there was a substantial relationship. If you look at the testimony, they had a relationship with both grandparents. They'd come down here, they'd seen the time. Again, spent weeks with maternal grandmother. And I would ask that you affirm all the court's rulings. Thank you, Your Honor.
Just briefly, Judge, we would ask that the court very carefully review the actual language of the appendix B to our brief, which is the memorandum and decision on page volume 4 of the record, page 13. The court's language is, it is in the best interest, child's best interest, to spend up to 7 consecutive days with each of the maternal grandparents. That is visitation. That is not anything other than visitation, and it is absolutely an attempt to work around the requirements of the statute, which were not met. If we look at volume 4, page 11, the court's language is the emotional and physical needs of the child. The emotional and physical needs of the children are unexceptional in that they, like all children, require the attention, care, and love of both parties, which, to their credit, the parties have worked hard to provide. This factor favors maintaining the status quo as the children are thriving in their current condition. That is not nitpicking the record. That is, in fact, the record. That is the judge's own language. When it comes to child custody, yes, there are 18 factors. And yes, 9 of them were neutral. The other 9 were not in mother's interests. The fact that the parties, while married in 2013 and 2014, agreed to have the mom stay home to take care of the children, that's an agreement that is in place informally between 2 married people at the time they're having children. When mom files for divorce, the agreement is not, and I will maintain you as a stay-at-home mom for the rest of your life and these children in the home. There's no agreement to that. And that ties right into the issues with alimony that was awarded, the spousal maintenance that was awarded in this case. While the court specifically notes that the purpose of spousal maintenance is not to maintain a lifestyle to which a person has been accustomed but can no longer afford, spousal maintenance is intended to ease the transition from 2 incomes supporting 1 household to 2 incomes supporting 2 households. 2 incomes supporting 2 households. We have mom who has chosen not to return to a corporate job, but is instead making $14,000 a year as a paraprofessional, as opposed to 6 figures where she was in corporate America in an insurance job. Nobody likes their insurance job. According to the court, she hated her job But is it not her duty as a parent to provide for her children as opposed to just do the job she wants to do?
Well, that job also suits the hours of school for children during the summer, after
Correct.
hours, that type of thing.
And so is it in fact the requirement that dad provide for mom so much income that she only works when the kids are in school? That agreement that she be a stay-at-home mom in 2013 is not binding on this court today. And in fact, my client had paid $85,000 to her on top of that savings account that you heard about, on top of a house with no rent and no mortgage. On top of all of these other things, he'd already paid her $85,000 in spousal maintenance at the time of trial. Following the award, we're now looking at over $240,000 in spousal maintenance to mom so that she can stay underemployed. That's essentially the reality of it. The testimony.
You have an issue with underemployed, but the children are thriving. You can't ignore that part,
You
right?
can't ignore that part. And it has to be taken all in consideration at once. And so the testimony was that mom was going to go get a master's in education degree so that she could have a fulfilling career, and that she was going to then be in education and her schedule would reflect the children's schedule. That was the argument made at trial. That was what the award of $4,500 a month was based on. But remember, alimony and spousal maintenance is based on two things: need and ability to pay. Counsel seems to be arguing or alluding to the fact that dad voluntarily quit his job. That is not the case. If that were the case, why would the company have awarded severance and termination? It was a layoff. It was a corporate layoff of middle management. That's what the evidence was. That's what it was. All middle managers in this company were making too much money on their commissions, and so shockingly, the company decided to get rid of that position. He has since been rehired at $85,000 a year. So he went from $330,000 a year to $85,000. So these are not consistent facts. And the fact that the court denied a motion to reconsider when that ability to pay has gone, it's an abuse of discretion.
You have 1 minute.
Thank you, Judge. And then the final topic that we had covered in our brief was just division of property itself. We believe it's a complete abuse of discretion for the court to give no consideration to premarital assets and holdings. In this case, the marital home that the mom was awarded was bought and paid for by dad before the parties even started paying. And yet 100% dad gets no credit for that. Dad gets no ability to say that I should at least get some equity in that home that I built. The court went through and every single factual finding on property was against dad. We believe that that is just a reality, that he made a lot of money, so the court felt like, hey, he can just pay for all of this. That seems to be the general tone. And if you read that decision at volume 4, if you read the court's decision, it is one where the facts don't matter. He's got a big income. We'll just let him take care of it with his big paycheck. That's abuse of discretion. And that doesn't take into the totality of facts in this case. Thank you. Honors, all of you.
All right, and so thank you very much for your briefs and your arguments, your very hard work in this case. This is a difficult case. Know how important it is to the parties involved. We'll get an opinion out to you just as soon as we can.
Thank you.
Thank you, Your Honors.
The last case on the docket is also from Sedgwick County. It's 127-556, entitled "The State of Kansas versus Juan Flores." Talent, we have
Mark Siebert, court appointed counsel.
for the appellee,
May it please the court, Assistant District Attorney Christiane appears on behalf of the state of Kansas.
Mr. Siebert. Do you wish to reserve any time for rebuttal?
Yes, Your Honor, if I could reserve 5 minutes.
That is granted.
Thank you.
You may begin.
Thank you, Your Honor. My name is Mark Siebert. I'm been court appointed to represent my client in this case. appreciate you all coming here to Sedgwick County to hear these cases. Judge Malone, it's certainly good to see you. Miss you and your trial work here at Sedgwick County. This case I find a bit troubling. I recognize that the factual aspects of it are troubling in themselves, but I can't help but think about some of those cases where an American citizen goes to some country, commits a crime, and then gets locked up forever. And everybody back here thinks, oh my gosh, what a tragedy. What kind of system of justice do they have over there? And all of those. And this was an individual who clearly was not an American citizen, was involved in a situation that is horrific in facts, but, and that's assuming, I mean, that they're all correct. The situation is he has broken English, somewhat broken Spanish, and is given a court-appointed attorney and is basically led to the podium to plead no contest in the hope that he might be able to get some sort of lenience from the court and then be sent back to Mexico where he's got some family. And the problem is that, and it really was unfair even to Judge Turnus, who does a great job, but he wasn't given any information to make some sort of a departure back onto the grid.
He had an interpreter, did he not? That was adequate,
The defendant did have an interpreter, yes.
and no complaints about that, about the adequacy, sufficiency of the interpreter.
That, I have not raised that. I think any issues that may have been going on there was probably more of a situation of intellect or what he was being told. I think he understood what the interpreter was saying, except for the fact that he went to the podium with the plea thinking he was facing a 55-month sentence, already having served a big chunk of that, and that he was going to be deported back to Mexico.
At the plea hearing, did the district court judge advise him of the maximum penalty for the crime?
He did.
So he was advised that this could involve
A life sentence, yes, yes. I think that, you know, and I recognize that, you know, with respect to some of the factual findings, it's abuse of discretion, but with respect to some of the legal issues involved here, you have unlimited authority and review. And I think some of the legal issues here to be considered are, was his attorney effective? Was it lackluster representation? I think also how does unconscionability or lack of consideration affect a plea negotiation? You know, I know we use contract law to kind of guide us through plea negotiations, but this gentleman, unfortunately, was in a worse position by entering a plea than he would have been if he'd gone to either a bench trial or a jury trial. I mean, I more than once I've had to try a case I'd rather not be trying because the cards seem to be stacked against me. And then we get in the courtroom and I don't know, some witness testifies something completely different than what they told the police, or a different jury panel shows up, or, you know, all kinds of things can happen. But the situation we run into is that there needs to be some consideration for waiving all of your constitutional rights and putting yourself in a position of subjecting yourself to a life sentence, especially, you know, at a young age. And there just wasn't any consideration. I think his attorney said, well, he was allowed to argue for a departure. Well, he would have been able to argue for a departure if he'd been convicted by the jury. He actually, like I said, by pleading guilty, gave up all of his constitutional rights, gave up all of his opportunity to confront any of the witnesses, and probably more importantly, gave up any ability to kind of educate the judge on what the facts and the circumstances of this case were. And that
He could at least argue acceptance of responsibility by plea. That's at least one small benefit that he could say he received. Is that right?
That is correct. Now, in federal court, you actually get some points taken off of your sentencing by accepting responsibility. We don't really have that here in Sedgwick County or in the state of Kansas. But I think acceptance of responsibility still has to be followed up with substantial and compelling reasons for the judge to depart by putting the case back on the grid. And I think they just threw this in front of Judge Turnus and said, be a nice guy and put him on the grid. And just so you know, he's going to be deported as soon as this is all over. And I don't blame the judge for thinking, well, wait a minute, maybe I need a little more information. I would submit that, you know, a problem for this Mr. Torres is that if he, you know, had gotten a 55-year sentence or 55 months sentence and been deported, he'd probably have some family back home to go to. Unfortunately, if he does this entire 25 years, by the time he gets deported, he's probably not going to have anybody to go home to. And so there's just an awful lot on the table here that was never even looked into.
Didn't the trial judge hold an evidentiary hearing on this motion and find the defendant's credibility was weighted against him?
With respect to actual innocence, yes. And I think the judge took into consideration, I mean, it wasn't ever a trial, so I'm not sure what all evidence the judge was basing that on other than the quality of the plea. There was this letter that apparently the client had written apologizing to the people involved, and that was being construed as a confession. And I don't know, I mean, people all the time apologizing for a car wreck or apologizing for this, that, or the other, and that doesn't mean they're accepting legal responsibility for it. It could be just, I'm just really sad that the relationship has been destroyed by this. You know, there was also some information about how this client had been abused himself, and we see that all the time, where people who are abused then go on and abuse. And, you know, I think it's important that we have, you know, protections and so forth for people who are being abused, but we also have some obligation to yesterday's victim of abuse. And then to just throw them in jail forever. That just doesn't seem very American, I guess. I think that the situation that we have here is that there could have been more aggressive defense work. There could have been better presentation of sentencing information to the judge. I think that he was taken advantage of. You know, he was told you need to plead guilty or you have absolutely no defense. And I just submit that was bad advice, and that was taking the easy way out. And that if you really are going to try to bet against the state and roll the dice on something like that, you better have some pretty substantial and compelling information. And that was just never developed. I think that as a matter of law, the court could find that there needs to be at least some consideration in a plea negotiation in order for it to be carried out or enforced. And that there just simply wasn't any here, and that it would be unconscionable for especially a person of foreign descent to give up every single right and throw it on a court without any real backing. That's just not going to work. And so I think he was suckered into believing that he had a 55-month sentence. And the reality is he's sitting and looking at the rest of his life in prison. And you know, I you know, on the strength of the underlying case, you know, we're not here on that to the full extent, but even at the plea hearing, he did at one point plead not guilty, and then they had a little recess, and then he said, I meant no contest or something to that effect. In some of his pro se filings, he was again arguing about actual innocence, but we never really got to that level because of, you know, of the plea and trying to get that. This was a joint collateral attack of the post judgment attack. It was both 1507 and a motion to set aside a plea, but I think you'll know that. But anyway, any other questions at this point? Well, I appreciate it.
You still have your rebuttal.
Thank you.
Good morning. Ben Christiana appears on behalf of the state. First of all, I think it's important to remember the standard of review when we talk about a post-sentence motion to withdraw plea. My colleague keeps saying lackluster advocacy, but as we know, post-sentence motion to withdraw plea, there has to be it has to be viewed in the light of competent counsel, which is that counsel's performance fell below a reasonable standard. And that there was a reasonable probability, but for counsel's performance, the defendant would have insisted on going to trial. And as this court knows, the Supreme Court has said that there is a strong presumption that counsel's conduct falls within a wide range of professional assistance. So what we have to look at is deficient performance as far as what was alleged in the briefs was that counsel spent limited contact with him. The record will set forth that counsel spent 30 to 40 minutes before the plea hearing with the interpreter and the defendant. Additionally, before the preliminary hearing, counsel made a record that the court was very generous with its time in allowing counsel and the defendant and the interpreter to go over the information. So the record does not support the allegation that there was limited less than 15 minutes of time spent with the defendant and counsel. As far as counsel's performance, taking this to trial, counsel testified that he was provided witnesses. He attempted to find those witnesses. The witnesses he found were either uncooperative or, so the witnesses he found were uncooperative, other witnesses he's unable to locate. Additionally, you have that counsel recommended a plea, and Mr. Siebert thinks that this defendant was suckered, I believe is the term that he used. Counsel was very clear in his testimony that he explained to the defendant multiple times, you are not guaranteed a departure. And in the plea agreement, the court even told him, you understand that the court is not bound by this agreement. The court can enter any lawful sentence and impose any lawful sentence. The defendant understood that. So
with the plea agreement, what did the state agree?
the state agreed to, for the defendant to plead no contest as charged, that he would be free to argue, which, yes, he would have been free to argue the departure had he gone to jail and been convicted. But again, this.
Wait, so the state never said we jointly agreed to depart to the agreement?
Yeah.
So there's no agreement terms
No, there was not.
on the plea agreement suggesting anything but a life sentence, but you're free to argue for departure.
Correct.
So
And
what was the benefit to the defendant of the plea agreement?
well, the benefit, as his plea counsel testified, was that if he accepted responsibility in front of this judge that was untried on departures in Jessica law cases, that counsel thought that this was his best ability to potentially get a departure. And counsel explained that he had a case before this same judge. It was not a Jessica's law case. He had a case where the judge granted a departure over the state's objection. And so he thought, given this apology letter that counsel discussed with the defendant and how that affected their case, he felt that the best way to do this was in front of this judge, accept responsibility, and that would make the best argument for departure.
He really didn't accept responsibility, though, did he?
He did not. He pled no contest. And he disagreed with the factual basis, but again, there was this discussion. And I guess what I would say is it appears that Mr. Siebert has an issue with a plead guilty as charged. We all know that there are plea agreements. Plead guilty as charged. In this case, it was no contest, plead no contest as charged. So this was not something that the defendant had to take. This was not a forced upon him agreement. He could have gone to trial, but it was by the recommendation of his experienced counsel that the best way, I believe, that you are not going to spend the rest of your life in jail is for you to take this plea and then we'll argue to the court. And just because he didn't get the sentence that he wanted does not mean that there was not consideration. It does not mean that he did not get a benefit from that plea. For Further, as far as
What consideration did he receive? State.
what consideration did he
I mean,
receive?
free to argue departure, that's, you don't have to have state's agreement on that.
No,
What
you
did the
don't.
state, what did the state give in return in this plea?
I don't know that the state has to give something in return.
Right, so they did nothing, so it's basically, you're charged with the Jessica's law, I'm not,
No, yeah, I
I'm
understand.
just setting the record straight. He was charged with Jessica law, one offense,
Yes,
and he pled as charged,
yes.
that's it.
Right, so I guess my position is that you don't have to, the state doesn't have to give consideration, right?
Correct.
So benefits that he received are also that the facts, the specific facts of what he did in this case were not put before the court. There was a motion for 6455 evidence regarding prior acts of this defendant that was not put before the court.
See, that was gonna be part of it, if you go to trial, all that.
Correct, correct. And as plea counsel testified, he felt the victim was a strong witness. He knew that 6455 evidence was coming in. The defendant did not have witnesses coming in to testify on his behalf. So he felt that this was the best way to potentially get the sentencing judge to give him some grace and grant this departure. As far as it being unfairly made, again, he didn't have to accept it. I think we've gone over what the consideration was, the reasons for why he would have accepted or would have accepted the plea agreement. He was not misled. Again, the focus seems to be on he was promised departure. The record sets forth that he was told multiple times he may not get a departure. So at this point, I would submit that there was no deficient performance by counsel. There was no prejudice by counsel. The defendant was not misled that he would absolutely be granted a departure. It was fairly and understandingly made. He was discussed multiple times with an interpreter. He did not have to accept the plea agreement. He could have taken it to trial, but based on counsel's experience, he felt that this was the best thing for his client. If there are no further questions, the state would just ask this court to affirm the district court. Thank you.
Police court, there was no consideration by the state. And I would submit that plea negotiations are governed in a manner consistent with contract law. And contract law clearly requires consideration in exchange of promises, something in exchange for something else. And the consideration that was presented here was dangling something in front of them that was worthless, made to look good, but it really was worthless. And it you know, from back in my consumer fraud days, I would have called it bait and switch. You know, he was baited with this 55 months, you're gonna go home and see your family, to, no, we're gonna lock you up forever. And that just strikes me as a violation of due process and a violation of constitutional law and violation of plea negotiation law. The state just didn't give up anything. And I think the error, the legal error that his attorney perhaps made, and I'm not here to badmouth the judge or the attorneys or anybody involved, but is when you have to be able to demonstrate substantial and compelling reasons to depart, even to depart back onto the grid. Acceptance of responsibility in and of itself, I would submit, has not been found to be substantial and compelling. And even outside of that, it still leaves so much discretion to the judge. And when you're in kind of a nasty case like indecent liberties or aggravated indecent liberties, it's extremely difficult on a district court judge to go out on a limb for somebody without some pretty good information being in front of them to rely on. And a lot of times, acceptance of responsibility together with the district attorney's office agreement to the departure, that is pretty substantial and compelling. But when the DA is sitting there and hadn't had to do any work whatsoever except threaten to use this information or that, there just wasn't any consideration. And quite frankly, I would submit it may have been better for the judge to have heard all of the story, not just the allegation. That perhaps I would have developed information for another departure basis of you know, that the acts in this case were not as substantial as they might have been in, you know, the ordinary run-of-the-mill aggravated indecent liberties case, or that there maybe was a relationship between these parties that was a little bit different. You know, we don't know because there was never a trial or an opportunity to develop any of that. I can tell you, you know, I've dealt with 6455 motions, and in sex cases, it's a bad rule. They can pretty much let in anything they want. But defense counsels can also sit there and say, you know, all that information, it's really just, you know, rolling the twine. All they're doing is just adding more allegations on top of more allegations and hoping that you convict somebody based on allegations. Or you can also argue, you know, Mix has got a pretty easy target to, you know, accuse him of doing something because everybody knows his past. And so, you know, it's not a dead end road simply because they may get some 6455 evidence in. You know, the thing that I just keep getting in trouble about is we have a foreign citizen come in here, not given a whole lot of legal advice other than throw yourself on the mercy of the judge, and then nothing given to the judge to help improve the mercy, and then sent off to prison. If that was an American citizen in Mexico or American citizen in Russia or in China or something, we'd be figuring out how to set up a GoFundMe page to get somebody to go over there and get them, or be talking to politicians about going over there and doing a prisoner swap. It's just troubling that, you know, regardless of regardless of what the crime is, to kind of bait somebody into a life sentence. Thank you.
All right, counsel, thank you very much for your briefs and your arguments. You both did a very fine job on this case. As I mentioned, we'll take the case under advisement and get an opinion out to you as soon as we can. And with that, this morning's hearings are completed, and so court is adjourned.
Good. Well, okay, they have broken.
Yes.
Scott, first time out in New York. See you.
See you. Say hello to Mark.
Nice to meet you.
We're gonna be getting together, so.
Good. You take care.
Good to see you.
Yes, you do.
You.
All right.
Yeah. Well, we will see you later.
Okay.